Let me begin with my friend on the right, or on Professor Clark, and move down the line.
Thank you. I would like to make a general point, Keith. It's been a fascinating day, and I'm delighted to be here with the rump audience that's left late on a Sunday afternoon. The absolute hardcore is here to listen to this. I was thinking when the comment was made about Bishop Tutu's remark about history, how I was struck when I first read that too. And I immediately thought of Elie Wiesel and the whole notion of making sure that this material does not go down the memory hole. The memory hole and memorialisation and the kind of things we've heard being done in Bangladesh are so important. And I think it's very important to put these things in perspective because historians and memorials have a role in making sure that stuff does not go down the memory hole. Truth and Reconciliation Commissions have a role perhaps to play in that. And sometimes, and I emphasise sometimes, criminal justice has a role. I mean, we all believed it, I think, that Nuremberg and the Nuremberg trials were a good thing, in part because they recorded with incontrovertible truth, I suppose, that the Holocaust took place and so on. But to go on from that, I've thought a lot about genocide in the course of the day, and there are at least three ways in which genocide are used, aren't they? One is a slogan. To be honest, much of what I heard today was genocide used as a slogan, a fuzzy one at that, with no real effort to explain what was meant by it. Secondly, and I've been an academic most of my professional life, and I love listening to academics, and I like academic courses, and I'm in favour of academic courses. And I think it's important there's a field that studies genocide in a broad sense. And Adam Jones, I think, offered some thoughts about how we might define that field. And then there's another way in which one can think about genocide, depressing in many ways. It's all a bit depressing, isn't it? And that is as a legal construct. And thinking about genocide as a legal construct commits you to a certain mode of approach. It commits you to saying, well, is there a treaty on this? What does it say? It commits you, if you're taking that treaty and putting it down in a statute in 1973, to ask, am I being faithful to the treaty, or do I want to go off on some other tack of my own? And if I do that, do I lose international legitimacy, and so on? They're very reasonable questions when one reads that 1973 Bangladesh statute that may provide the basis for some trials. And then, of course, one's forced to the question of proof, because if you want to prove genocide against someone who's in a dock in Bangladesh in 2009, it's not much good to have a great quote from General Kean, who unfortunately is out of the jurisdiction, and the rest of the Pakistanis are not going to be within the jurisdiction. So the question is whether one can find some individuals currently in Bangladesh who can be brought to account, and presumably some of those I've heard described as militias or Biharis or collaborators or something of the kind. And one needs to know a lot more about the facts before one goes down that particular road. One needs to think through the details of the crimes. Now, I'm going to stop at this point, but I do hope all of you managed to get a copy of the 1973 legislation, which was circulated, at least the substantive parts of it. There's a lot more than that in the Act, but I would commend you to look carefully at it and think. Pretend you're a prosecutor, pretend you've got to prove that. Moreover, ask yourself, does it adequately reflect the state of international law 1971? Because one has to get one's head back to that point. That's when the crimes took place. What was the law that could be applied at that point? Keith?
Very good. Thank you, Roger. Oh, Professor Clark, I'm sorry.
We can skip the
May I
applause.
then turn to Council Matters, because Council Matters is the Queen's Council, and ask from the practitioner's point of view how you see these issues.
Well, I am been very involved in the effort to try to bring perpetrators of mass crimes to justice, and I would very much like to see this effort extended to Bangladesh. We do have a 73 statute. There was a 72 collaborators order, and then there was an amnesty under the order in 73, and then the order itself was repealed in 75. But the statute remains. And the statute does deal with genocide. The genocide was a crime that was created in international law after World War II, and it was not used in Nuremberg at all, because at international law the crime has to exist at the time the act was committed in order to not to violate the prohibition against retroactivity, and the crime of genocide did not exist during World War II, so it wasn't used in the Nuremberg tribunals. So what we have in a legal sense in 71 is the first genocide the world has ever seen. I mean, practically, factually, you can apply the definition historically to events that happened before the law came into effect. But legally, this is number one. And you can understand why there's problems in dealing with it when it is the first. And then, of course, we didn't have an international tribunal at the time. The whole international tribunal movement collapsed because the Nuremberg tribunal was repealed in midstream or dismembered in midstream because of the Cold War and in the fear that prosecuting all the people online, including Croat-Waldheim, who was in the line, would lead to a disaffection of Germany and maybe Austria in trying to win their hearts in the Cold War. And so what we had is not only the end of international justice in 48, but a determined attempt not to resurrect it during the whole of the Cold War. And we only saw it revived again after the Cold War had ended with the ICTR and the ICTY and so on, the International Criminal Tribunal for Rwanda and Yugoslavia, and then there's been a whole bunch of them since. So now what we're faced with is a situation where we have this event where there finally seems to be both a willingness and ability to bring it to justice, and the question becomes, mechanically, how do we go about it? And there are a few choices out there. One of them is simply to use the 73 law. Now, the 73 law has disadvantages in the sense it's an old instrument. I mean, it's the first instrument. It doesn't have the benefit of the experience of all these subsequent tribunals and rules and prosecutions that have developed since then. And of course, it is only domestic. It's not international. But it does have the advantage that it's there, and it doesn't require anything more except the mechanics of getting it going. Build a building or rent some space, appoint some judges, and they're off. And I think, as far as I'm concerned, either could be made to work, and it's really for the Bangladeshis to decide. Obviously, the international community would be willing to help. The genocide that bears the nearest comparison to it is the Cambodian one, because it's closest in time, and it's also in the same geographic area, and it also started many decades later. And that was a hybrid tribunal that had both an international and local component, and it was created by the General Assembly of the United Nations. But I expect that would be more difficult for Bangladesh for a number of reasons. One is, as we've heard throughout the day, this genocide has not had the international profile that the Cambodian genocide has had. And secondly, I'm not sure that we need the General Assembly to motivate Bangladesh to get this